right, welcome back to the Prima.Law podcast. I'm your host, attorney James Betzold, and today we're going to be talking a little bit about Operation Twin Shield. That's the recent fraud investigation and interagency operation with USCIS and ICE, and probably the federal prosecutor as well, over there in Minneapolis, Minnesota. Okay, we're going to be talking about that because I think it's not just, oh, hey, look, we uncovered some fraud. And it's not just playing into the Trump administration's narrative that everything about immigration is awful and everything is fraud, and none of them should be here. But I think it's actually a bit of a warning shot to immigrants and immigration attorneys as well. So we're going to be getting into that in just a couple minutes. First, I'm going to talk to you about our sponsors for today. So we're always sponsored by Prima.Law. Prima.Law is immigration case management, filled with all of the immigration tools you need to run an effective immigration practice. So whether you're doing employment cases to help bring people to the U.S. on employment visas, or whether you're filing family petitions with waivers or humanitarian petitions for victims, Prima.Law is your choice for success with that. Why? Because we come with a bunch of predefined case types, over 140 predefined case types that have the checklists, the forms, the to-do lists, all the tasks you're going to need to get done in order to complete the case, with amazing visibility using our case management board. That's a very visual, smart table that helps you see what cases are at what status, which ones need to get moving along, and which ones we're just waiting on the government to do something for. You can find a free 15-day trial at Prima.Law. All right, now let's get started with the show.
To Operation Twin Shield, an enforcement effort of U.S. citizenship and immigration services with absolutely invaluable support from U.S. Immigration and Customs Enforcement, the FBI, and DEA. What they found should shock all of America. Focusing on a list of over 1,000 target cases involving more than 900 individuals, our officers encountered blatant marriage fraud, visa overstays, people claiming to work at businesses that can't be found, forged documents, abuse of the H-1B visa system, abuse of the F-1 visas, and many other discrepancies. Over the course of the operation, our officers found indication of fraud, non-compliance, or public safety and national security concerns in nearly a little less than 50% of the cases interviewed. We found troubling patterns with the Uniting for Ukraine program that should have raised serious concerns under other administrations, such as an individual filing to sponsor more than 100 aliens, and organizations sponsoring hundreds. We are continuing to investigate these cases. In one case, officers identified an alien who had overstayed his visa waiver, who was the son of a known or suspected terrorist on the no-fly list. He had previously been found to have engaged in marriage fraud, which resulted in the denial of several immigration benefit requests. He was arrested and is now presently being returned to his country of origin. In Kenya. In another, an individual admitted to obtaining a fake death certificate in Kenya for just $100 to prove he was no longer married. In reality, his wife is alive, living here in Minneapolis, and is the mother of 5 of his children. And incidentally, he has another wife living in Sweden with whom he has an additional 3 children. And finally, I wanted to note, in one case, an alien engaged in marriage fraud by taking advantage of an elderly U.S. citizen spouse, including threats and severe neglect. The American spouse was able to divorce the alien with the help of her family and caregivers, but the family still lives in fear of retaliation from the alien over the failed marriage fraud scam. We will be looking at grants of immigration benefits already given. We will be looking at other patterns, and we will be re-examining benefits to determine whether rescission, revocation is appropriate in any of these cases. We will continue to tirelessly work with the U.S. Attorney's Office here in Minnesota, as well as in every other jurisdiction, to make sure that these cases are treated as they should be, and that aliens, attorneys, preparers, others who engage in immigration fraud are properly punished.
Okay, so we want to start by talking about Operation Twin Shield. Now, this is what they call an interagency operation. It just means there are multiple government agencies involved in order to accomplish their goal. Right. So what they did first is they used FDNS. That stands for the Federal Fraud Detection and Narc Service, probably something like that. And what they did is, they go through data and they say, all right, well, there's a weird trend happening over in this place where a lot of people are filing these applications, and it turns out later we're finding stuff. So maybe we need to go look further in this direction. So a good thing you might find is if there's a spike in a certain type of application filings in a certain geographic area, which might mean, right, that could be an indicator of fraud. It could mean that, all of a sudden we're getting 30,000 applications a year for U visas from this one geographical area. And most of them are coming from this one police department, like the law enforcement certification is happening in one police department. Okay, yeah, that may be a little suspicious if all of a sudden you go from having, a couple hundred a year to 30,000 a year. So they're looking at data in order to determine where they go next. Okay, so that's what the FDNS, the Fraud Detection and Narc Service, I suppose. I don't really know what it stands for. I know it's out there. It's like, we'll put it in the notes or something. Anyway, so that's one of the main things that they mentioned in this press release is that that's where they started. They were looking at the data and they said, hey, something's going wildly wrong in Minneapolis, Minnesota area. Okay, so they took a look at about 1,000 different cases and they started investigating them. And between USCIS and ICE and FDNS, they were actually doing site visits, which is something that USCIS can do, right? So if you file a family petition and you say, yeah, we live together at this address, we've been living here together for 5 years. I had been married before, but now I got divorced and now I'm married to this person. So this is where we're living and they're petitioning for a visa for me. USCIS they have the authority to do this. They can send agents to the field. They can go to that address and investigate, right? When you sign that immigration form, you're saying, I swear that all this is true to the best of my knowledge, et cetera. So they're going to go look. They can go look. And sometimes they do. And, we've seen a couple cases over the last 15 years. And again, it doesn't happen a whole lot unless there's one of these red flags that really sets things off. We have had a case where somebody had filed multiple petitions previously, but the marriage never seemed to work out. So they never made it all the way through the process. Anyways, USCIS does a site visit and they can say, hey, who lives here? They can talk to the person at the door. Hey, does, the visa petitioner live here? Yeah. Okay. Does their spouse live here? And if they say, yeah, okay, well, great. Can we come in and talk to them? Yeah, they can do that. Now, some people may say, well, do they have a warrant? Do they need a warrant for this? No, you don't need a warrant for that because what they're banking on is the fact that you're filing an affirmative application with immigration. And if you don't let the site visit person in, they can just deny your application. That's easy. And then they can prosecute you for fraud as well because they can say, well, now we suspect you of fraud because you got all squirrely when we went to your house to check up on you. Right. And then they can actually build a case and then put you in federal court and things like that. So no, it's not that they have or need a warrant, right? Like I know when we're online, when we're listening to, TikTok videos or whatever about, people who confront ICE, and ICE is picking up people like crazy now. People are asking them, hey, do you have a signed judicial warrant? This is a completely different situation, right? This is where someone's affirmatively saying, I want this visa. I'm promising you that all this information is true. And I agree to a site visit because I know if I don't allow you in, you're just going to deny my application. Right? So it's a different type of authority. There should be no reason not to allow a site visit in a legitimate case. Okay. So that's what happened. And out of the 1,000 high-risk cases that they identified, they were able to confirm something like 275 that were actually fraud, where there was actually like really concerning fraud, not just, oh, we don't know if you really love each other enough to be married, or we don't know if this is that. More like, hey, you just admitted this guy paid you. And so that's why you filed an application for him, and that's why you got married to him. But it's not like a real marriage and you don't even live together. Those are the type of fraud cases that they're looking for. Now, that's a pretty high percentage. I mean, if you flag 1,000 cases and in a day or two you confirm that 275 of them are definitely, at least in your view, definitely fraud, that's 25%. So I don't know what's going on in Minneapolis. But that's a pretty big amount of fraud that they found. Now, of course, that's not 25% of all cases filed. No, that's of the ones that they identified using their data analysis and, things that looked suspicious, things that threw red flags, etc. But still, not an insignificant amount based on the data that they're going through. So that's important to know. Now, all right, now let's understand a little bit about the enforcer, the FDNS. It is the Fraud Detection and National Security Directorate, not the Fraud Detection and Narc Society, okay? It's the agency at the heart of USCIS that their job is to look for fraud nonstop. That's their everyday job. So they're not individuals who are doing the interviews. They're not the ones reviewing the applications. They're looking for trends. They're looking for red flags, and then they'll go and dig deeper on those cases, right? And now we're going to talk a little bit about this later, but of course, USCIS and the federal government, Department of Homeland Security, they're getting access to all of this data-driven analysis, right? These AI tools that can comb through millions of records in the blink of an eye and identify trends, identify things that might be fraudulent. It can identify inconsistencies, right? I'm sure there's still some level of hallucination that happens, but these tools are getting stronger and stronger. So I think, that's an important point. So people working for FDNS, and I remember reading somewhere that they were hiring more FDNS officers. I don't know for a fact that they have, but it sure seems like that would be the top of the Trump administration's list. In fact, I think that's mentioned in Project 2025. We can go and look at the old video we did on that to confirm. Okay, so let's see here. They have been granted full law enforcement powers. Okay, so historically they're investigators. Now they can carry firearms, they can execute warrants, and they can make arrests. So they have full law enforcement powers now. That's quite a big shift. Why is that such a big shift? Because USCIS, right, where FDNS is a sub-agency of, it was actually formed in 2010, and it was formed in 2010, and it was recently officially made a subdirectorate of USCIS. I think in 2018 or 2019 that happened. So it's more and more formalized, right? It's a real part of USCIS. But USCIS officers don't carry guns. They're not law enforcement officers. Typically, USCIS officers are adjudicators, right? They're people typically with college degrees who are reviewing applications to make sure that you meet the criteria when you're applying for a visa, right? So to now go and give them guns, geez, I don't know if that's a great idea. It kind of will pull the shift away from the focus of the agency, I would think. So that's something, I don't know, kind of unfortunate. I hope we're not going to have to see that when we go bring clients to interviews, because there's nothing a little more nerve-wracking than, your client's already nervous because this is a big day. We're going into some big government office building. We're going through security. Yeah, those guys are carrying weapons, usually a security officer. But then to have to sit in a room with the person doing the interview and probably somebody else now is going to be carrying a firearm, that's a little overkill. No pun intended. All right, so that is a huge shift for USCIS now that they're arming the FDNS officers. Now, immigration is pretty famous for having some gray areas, right? And there's nobody better at finding those than attorneys, right? That's essentially our job, is to find a legal avenue to get the result that we want. Now, over the years, there have been some attorneys who have taken more and more and more liberties with what they're filing. So a couple important things to remember. When you file an application with USCIS or the Department of Labor or the State Department, the attorney's signature on there is affirming that this is a legitimate application filed for an appropriate purpose, right? It's not to delay. It's not like in court. You might file something to delay proceedings. You can't do that as an attorney. So the purpose is because they're eligible for this benefit. So what has happened in years past is people have filed certain applications thinking, oh, yeah, maybe the client's not really eligible for that, but it's going to get us to this other place where then we can do something else. Okay, so in years past, that has worked in certain situations, right? Until it no longer does. For example, there was a time, I know it was before the time I started practicing, but attorneys would file just willy-nilly an asylum application for someone who wanted a work permit. Why? Well, because that was the only thing they could file that would end up giving them a work permit within about, maybe 90 days, maybe 180 days, certainly less than a year. Now, of course, the client needs to know, hey, this is going to result in you possibly being put in removal proceedings. This is going to result in you being in the system. You might have to go to immigration court. You might get an order of removal at the end of it, etc. But asylum cases were and still are taking so long to be decided that you might stay in that limbo position for 10, 20, 30 years with a work permit. Pretty great deal. What's the problem with that? The problem is if you're filing an asylum application that's not even facially valid for an asylum case, right? Asylum isn't just, I want to get a work permit. No, an asylum is, I have a fear of persecution. Maybe I've already been persecuted in my home country, so I can't return. And I'm being persecuted by the government or someone the government cannot or will not control. And that persecution is because of my race, religion, national origin, political opinion, or because I'm a member of a particular social group. Okay, so you have to be able to identify all of those things in order to win an asylum case. But what happens when you don't even get a chance to present your case for 20 or 30 years? Well, people get a little soft with the rules. They get a little loose with the criteria, and they may say, well, you know what? This is going to happen, but it's not going to happen for 20 or 30 years. So technically, you should not be doing that. That's an abuse of the asylum system. And we saw it get abused, I'm not going to say by attorneys, but by people entering at the southern border, for example, under the Obama and Biden administration, under the previous Trump administration. People who come to the border nowadays as well, if they do now get to a point where they can file for asylum, a lot of them don't know what the real criteria are. And so they're just saying, well, I fear to go back because they told me that's what I need to say. So I have a fear to go back and et cetera, right? But it's not really fulfilling that requirement, those requirements for an asylum case. So as attorneys, you have a special responsibility to not file frivolous actions, right? Or apply for benefits frivolously. So there is that issue. Now, that's not the only one. I do know there was a time, and I watched this happen. We did not do this at our firm, but people would say, hey, my kid has cancer and I want to get a green card. What can I do? And we would have to say, well, you got to go to immigration court, because in immigration court, that's the only place you can apply for cancellation of removal, right? And cancellation of removal is, you have a U.S. citizen spouse or child who is going to suffer an extreme and unusual hardship if you can't continue living here in the U.S. Now, the level of hardship you have to show is so high, it almost never works, okay? But in those rare cases where you've got a kid who's got cancer and needs ongoing surgeries and medical attention and things like that, well, then there's a chance, right? So what some attorneys would do is they'd say, well, we can't file anything to get you into immigration court, because there was a time, believe it or not, where you would go up to ICE and say, hey, I've got this client who needs to get in immigration court because they've got all this stuff going on and we think they qualify for cancellation, where ICE would say, that's not our job to put people in court. The ICE attorney would say that, right? And there's really no way to go and deliver yourself to immigration and say, please put me in court. Now, I think it's a little easier to do that today if you wanted to. You just got to stand outside an ICE office or go walk into an ICE office and say, I don't have any papers. What are you going to do to me? Then I think they'll happily put you into proceedings. But at the time, they wouldn't. They would say, no, we only have so much money to work with. We're going to focus on the criminals. We're going to focus on the people who are a danger to society. You're not. We're sorry about your kid. We're not even going to, you could deliver yourself to us. We don't care. We're not going to touch you. We're not going to put you in proceedings. So be on your way. And so what the attorneys would do is some would file an asylum claim, knowing that they don't even have an asylum claim. But they would file it because eventually that gets the person put in removal proceedings. If they don't pass their asylum interview, right, they get referred by USCIS to the immigration court, and then they're in. Right now, they got in trouble for this as well. There were attorneys who were doing this who got in trouble because essentially it was a frivolous asylum application. So it did not play well for them or their clients once it caught up to them. Okay, so that's another thing to be considering now that we know the FDNS is out there looking at anything that could potentially be fraud. There's also other types of visas that some attorneys try to fit everyone into, right? And we all know about the T visa. Well, maybe we don't all know about the T visa. So let's start with the U visa, right? The visa for victims of criminal activity. If your client's the victim of a certain type of crime, usually a serious one, you get a law enforcement certification saying, yep, they were a victim, they helped us, and they're going to keep helping us. And then you can file with USCIS for a visa for them. Well, this is less subject to abuse because you need that law enforcement certification. Now, if you know someone in law enforcement and you've got some sort of a scheme set up where they're getting paid for signing law enforcement certifications, okay, yeah, there can be fraud involved in that as well. But less common, I would say the U visa is less common for actual fraud because you need the crime to be reported to the police, and the police need to certify that. They need to sign off on it. Now, the T visa is a little different. A T visa is for someone who's the victim of human trafficking. And over the last, let's say, 6 or 7 years, due to changes in case law and policy at USCIS, and a lot of good work that was done by victims advocates, there's a lot of attorneys, and I'm not even going to say it's a lot of attorneys, but it's possible to fit someone into a T visa where years ago they may not have qualified based on previous policy, right? So it is possible to get someone into a T visa if they're suffering domestic violence, and let's say their spouse actually brought them to the U.S. to serve them here, right? They actually brought them into the U.S. They didn't really have a choice about it because the kids are here, and there's a lot of pressure on the parent because of that. But now let's say the spouse, the wife is brought here. She has to work at the house and she's getting beat all the time and she can't leave. She can't make friends. She can't go to church. Finally, she makes a friend somewhere and they bring her to an immigration attorney. And they're like, hey, you've actually been the victim of human trafficking here. So it's really more about awareness of these different situations that will qualify someone for a T visa now. All right. And when we look at the number of these visas that are filed, again, 5 years ago, the USCIS was never meeting their limit, which is 5,000 a year. They can give out 5,000 T visas a year. Now, that number has gone up, and we can provide those numbers at some point. I can't remember exactly what they're at. I think it's somewhere around I don't know if it's 16 or 20 or 30,000. There's a backlog essentially, right? So there's a backlog on T visas where they never used to meet that cap, but that's more driven by awareness than much else. However, because there's no law enforcement certification requirement, right? The only requirement under the T visa is that it gets reported to law enforcement. So if you have a letter that says, hey, FBI, I was trafficked into the United States. Here's the details. Let me know if you want to talk and investigate, and I'll participate. That can be enough in many instances for the law enforcement notification requirement on the T visa. So you don't need them to respond and say, yes, we certify. You just got to prove that you reported it. And I think one of the reasons that there's no certification requirement is because there's so many places you can actually report this to, but they won't call you back. Or they'll say, well, that happened a long time ago. We're not even going to create a file. We're just going to file this away with the incoming mail from this date and not take any further action on it. And because Congress understood that can happen, they wanted to make it easier for victims of trafficking, so they did not include a certification requirement from law enforcement. But I think some attorneys are looking at that and saying, well, so if I can get a client to say that they were trafficked into the United States and they can come up with some bare bones story, we can just fire off a letter to the FBI, call it good, we file the case, and they get a work permit. I think we're going to see that get investigated. And it's not just me giving them that idea, saying it right now. It's the fact that it's in Project 2025. It gets mentioned there. The U visa, the T visa are mentioned there already. And it's kind of funny because they say we don't even need these visas because the S visa is out there where law enforcement can sign up for a client to get an S visa, which is disingenuous because I think maximum 5 of those a year are given out, because law enforcement just doesn't use it. They're not encouraged to. They don't know about it. When a lawyer points it out, they're like, we don't want to. They already gave us what we needed. And typically the federal government, the ICE, right? The ICE attorneys or the ICE police, the Enforcement and Removal Office, will say, you helped us. We're just going to not deport you, but we're not going to give you a work permit because you're unlawful or you're unlawfully present. So those are some other things I think we're going to need to look out for is how much more scrutiny are they going to be giving specifically T visas because there's no law enforcement certification requirement. But also, there's that famous VAWA visa, Violence Against Women Act, right? It stands for Violence Against Women Act. And what it does is it provides victims of domestic abuse or family abuse, right? It could be a child, a son or daughter abusing a parent. It could be a parent abusing a son or daughter. It could be a spouse abusing a spouse. In those situations, there's no law enforcement certification required either. Now, the case is stronger if there's a police report, but it's not strictly required when there's enough testimony from the victim. So I also happen to know, and this is no surprise and it's no secret, that there are attorneys out there and other unscrupulous individuals who will take any case and say, I'll get you a green card, or I'll get you a green card in a year, and I'll get you a work permit in a few months. It's going to be great. No worries. Client goes in to talk with him and they're like, okay, now your kid's mean to you, right? Or your U.S. citizen spouse beats you, right? Or, yeah, your parents, they hit you, right? And they're really trying to create a visa case or a VAWA case where it doesn't really exist. And that's where I think we're going to see a lot of danger because these are so easy to say, oh yeah, it happened. I'm going to sign an affidavit about it and everything. And you can include enough details in there where it should pass the credible evidence standard for USCIS to approve it. But I think we might see some more pushback from USCIS because they're so interested in uncovering fraud. And if we look at all the types of visas that are out there, there's not many visas where you can apply for it and within 6 months, just you have a work permit and you're well on your way to a green card. So I think the things like T visas and VAWAs are going to be subject to that. So of course, they're not the only thing, right? Of course, there's always the classic marriage fraud, getting married for money, getting married out of pity, or, hey, I'll do you a favor and I'll marry you and then you can get a green card. That sort of baloney, which should not be happening. And that's always going to exist. And I'm sure they're always going to catch people doing that as well. Right? So there is that. And of course, then there's employment visa fraud, which is, according to Operation Twin Shield, Operation Twin Shield. I think that's what they called it, right? They found some H-1B fraud going on there, which we talked about in a previous podcast. So there's really no area that's safe, or that's going to be free from scrutiny going forward, because they used this press opportunity, this press conference, as an opportunity to say, hey, here's an example of what we're capable of, and we're going to keep doing it, and we're just going to follow the data. We're going to find where those red flags are. We're going to find where there's patterns that don't make sense or where there's a spike in filings of certain petitions, and we're going to go to those places, and we're going to do site visits. We're going to investigate, and we're going to arrest people when they're committing fraud. So what does this mean for attorneys and immigration professionals going forward? Okay. We can expect to see more initial denials, maybe more requests for evidence if we're lucky in those circumstances. Although, I can report in our office, the government is less likely to issue RFEs. And that's just a trend we've seen across immigration law since the new administration started. So they don't want to give you as much of an opportunity for a request for evidence. However, I will tell you that we found this. There was one case we had not too long ago where we needed to submit a copy of every page of this person's passport. And we did. The only thing that we didn't include was the outside cover. And then instead of an RFE, they sent us a denial saying, you didn't include the cover to the passport. Right? Now, if you know about passports, because I'm sure everybody has one who's listening to this, there's literally nothing that happens on the cover of the passport. They don't stamp it. It might have the name of your country, but all the biographical information you need, country, et cetera, that's all on the inside pages. And so what we did there is we filed with a 290B saying, hey, that was inappropriate for you to deny it because of this. Here it is. And we want you to reopen and reconsider this right now. And they did. Took a little bit of extra work, but it avoided having to start an adjustment of status process from zero. So that's one thing you can try if that comes up. But what we can expect as attorneys and professionals in this area is more of these things, right? We need to be even more thorough in vetting these cases, in reviewing the evidence that gets sent out with the cases. We want to make sure that they're complete and thorough, right? So when we're using our tools, we want to analyze and say, all right, did we meet the bare minimums? And what else can we add to make it stronger? And to just have a working knowledge of what you actually need in your cases to keep them strong so we don't get those pesky denials or RFEs. And for things like family cases, victims cases, employment cases, everything, more intense interview preparation is going to be necessary, right? As you prepare your clients, you're going to want to say, okay, we're going to go to this I-130 interview because apparently that's a thing now. And when we go, you got to know, because you live at the same house, we as a firm have verified that as best we can. But they're going to ask you, hey, what's the bathroom look like? When you walk in the kitchen, where's the microwave? What color are your laundry machines? Do they open from the front or the top? Those are the sort of questions and those sort of details, right? Your shower curtain, what color is the shower curtain? Does it have a pattern on it? What color are your walls in your bedroom? Those sort of things. They'll ask those to you individually, and your answers better match up because what they're doing is testing for fraud. So preparing your clients for those interviews, I would say accompanying clients to these type of interviews as well now too. I mean, if you think about it, they're going to have potentially somebody with a firearm and the authority to arrest them in the room at some of these interviews. So as the attorney, you want to be ready. Not only is this an opportunity for you to be a lawyer and to represent your client live, but it's an opportunity. I don't want to call it a business opportunity, but you're going to have to charge for it, right? There's no way to run a practice if you're taking a whole day to go accompany to a client to an interview or multiple interviews per week, things like that, depending on how far away the office is and whatnot. But still, that's going to be something that you're going to need to consider as you're preparing your clients, as you're signing them up, just to prepare them for, hey, I used to not go to these interviews. Now we think it's a good idea. There is an extra cost associated with that. Here's our table of prices for that. And here's when you have to pay that in order for me to actually go with you. Because if you get arrested, I still want to get paid. That's just the brute reality of, having to run a business. So more intense interview preparation is going to be necessary at every stage of the case. Because what we're seeing now, even with like family cases, I-130s, they'll call people in for an interview. Oh, you're undocumented? Come in for an interview. All right. Other core things that we're going to need to do as attorneys. Interrogate your case, right? Vet it yourself as best as you can, right? If a client starts providing contradictory information, you need to know that and be aware that, hey, this person might be trying to use me to help them get a fraudulent case through. And you need to be prepared for that because there are people who try that. Right? I don't know if there's any immigration attorney who's been in practice for more than a few years where someone came in and said, well, what if I just don't tell immigration I never left? Is it okay then? Can I get a visa then? Like I always say, no, that's not okay. You may not do that. And now I can't help you because you did tell me and now I know and I have ethics and I can't do that because I don't want to lose my license for your crapshoot at filing a case, right? So just maintaining your standards, maintaining your own ethics, your own dignity as well, and being able to communicate that to the client. Also, you want to put terms in and clauses in your retainer agreement for those situations because there are people who you will not be the first attorney they talk to. And the last attorney told them, no, because you left and came back, now you can't do anything for you. I can't help you. Go find someone else. They go find another attorney and then they just don't tell them. Right? So my notes in my case management system, Prima.Law, of course, if you're following the sponsor here, we're not going to put information in there that we don't know or that the client never told us. When we ask, hey, when was the first time ever you entered the US? And then did you ever leave? Nope. Okay. Well, garbage in, garbage out. If they're giving us a line of garbage, that goes in, that goes out. And we want to make sure that that stays consistent, right? Because one thing clients will do is with the attorney, they may say, yeah, no, I only ever entered one time. And then when they're meeting with perhaps a paralegal during the interview, and the paralegal says, so did you ever leave the US? And they'll be like, well, kind of, but not really. So let's just put no for that one. Well, my paralegals are trained to say, whoa. Tell me more. What do you mean not really? When did you leave? And that's when we find out. We find out when we're hours and hours into case prep, when we've given them all the checklist items, when we've given them a checklist to work off, and we've invested time and money into this case already. And now we find out that maybe they're being dishonest. You want a clause to protect yourself in your retainer agreement that says, hey, if you monkey around with us, we can close your case and there are no refunds because of the way we formulate the retainer agreement. That keeps everyone honest. So if they know that going into it, you're going to find that happens less often, right? So your internal memos, right? Your notes, those are going to be things that protect you. If you do get called, by immigration and you're ever in a tribunal where you need to defend yourself and your ethics counsel tells you, or your state bar tells you, no, you got to tell us. We want to know what's going on. What did they tell you? What didn't they tell you? And where you can ethically divulge that, you want to have a record of all the notes and all the conversations that show that no, at no point did they admit that they triggered a 10-year bar or the 10-year permanent bar or the fraud bar or the smuggling bar or any of these other bars. And as you're preparing the case, if you can effectively question the case, right? You've got the finished visa application, the family petition ready to go. Maybe it's an adjustment of status. And you can ask it using your own AI tools, right? And of course, there's a really great AI tool that we built into Prima.Law. So once you generate your final package, you can start to ask it questions. Hey, is the data here internally consistent? Is there anything to indicate that they ever triggered any other bars? Is there anything in the system to indicate this, that, or the other thing? Like that's the type of tool you want. So it's going to look at all your notes and it can look at all your tasks and all the phone calls and all the documents they submitted. And you can really ask those questions and get legitimate answers. So that's going to be something that's very important as well, is being able to use those AI tools and to document everything. You want stuff documented. Okay. So document everything, fortify your retainer agreement. The next point here is you want to control your environment. So in times past, there have been clients who've come to the office for a consultation. Maybe they bring 1, 2, 3, 4, 5 other people with them. One thing I do now, almost without exception, right? Very rare exceptions. And my clients are primarily Spanish speaking, so hablo español y no necesito a alguien más para ayudarte. No, yo te puedo conversar bien. I don't need a translator, right? Someone comes in speaking Spanish, I got it. I will speak to the immigrant alone first. And this has ruffled a few feathers. If you go look at some of my Google reviews, there are a few people who got kind of upset about that. But we have to maintain confidentiality, right? We have to maintain confidentiality. I don't want to be assisting an abuser unknowingly, right? And if there is a VAWA case that is legitimate, I need to know right from the very beginning. Because it literally could be the difference between life and death, right? That's how severe those cases can be. So definitely meet with the client alone first. The client alone first. Preserve the attorney-client privilege. Any problematic questions, criminal history stuff, get that out of the way before you start bringing in the rest of the family. Because once they're in there, they turn into witnesses against you if there's some allegation of fraud or something in the future. So be very selective in who you let into the consultation. Now, it's no secret. If you do family immigration, the husband's going to want to be like, hey, I'm the petitioner. Shouldn't I be in there listening to what's going on or what the plan is? Yeah, you got to use good judgment. Okay. Do a screening first, but know who's in there with you. Also know that they can't be recording right? We don't want that. We need to be able to foster an environment of openness where they can feel free to ask any question, and you can feel free to answer any question honestly and within the confines of the law. Now, I know there's going to be some people who say, well, I don't give any illegal advice. Okay. So why do I need to be afraid if they're recording me? We all know that words can be twisted, right? We all know words can be twisted. And it's much better if your note system or your case management system is the source of authority on what happened in this conversation and what didn't. That's better if you control that, not the client, right? That's the attorney, that's the professional's job. Now, the flip side of that coin, right? Maybe you, and I don't know, I'm a little bit on the fence about this right now because I also like having the ability to speak clearly and freely without being recorded even by myself, right? But there is the opportunity now to, to make an audio recording. Use your laptop or your note-taking system, or I know some people have these little AI pins that'll record conversations and take notes, and that's how they like to keep a record of what was talked about during the consultation, and then that record stays with them, and it has all the little details that the client doesn't need. Look, the client needs to go out the door knowing whether there's anything that can be done and whether you can help them and how much maybe it's going to cost. They don't need to know every little detailed step. They don't need to know that this form gets filed first and then that form and then that form and then that form. It's oversharing on the part of an attorney or immigration professional. All right, so you definitely want to control your environment. So we also more recently will say, you know what? You don't need to take pictures of the whiteboard. I'm going to draw something on the whiteboard because I want you to understand it. But that's not for you to say, oh, I'm just going to take a picture of everything that's on the whiteboard. When I do allow it, which is not very often, but it only has very generic information. It's not going to show them all the steps that they need to take or all the little details that they need. And I have a disclaimer actually magneted to my whiteboard. So if I get a client who comes in and thinks they're just going to start taking pictures, I say, actually, either we don't allow that. If there's something you don't understand, I have notes. We can review it again later. Or I could say, if you're going to take a picture of that, just make sure you get that disclaimer that's in the corner that I've magneted there, right? So it's stuck up on the whiteboard as well. Oh, that's how we do it. And make sure that you can read everything here is estimates only. This is not legal advice. This is not specifically for you. You shouldn't do whatever it says just because you think it's, no. There's a pretty good disclaimer that I wrote there because, we've had clients who come back multiple years later and say, well, you quoted me $500 for that. And I say, yeah, well, that was a decade ago, my man. And prices have gone up. And they want to pull out a picture and show, look, this is what you said and blah, blah, blah. I'm not going to argue with you about my legal advice. And so I'm not going to facilitate that either. So I would say just be very selective in your photograph policy in the office. In fact, probably useful to put out a sign that says there's a strict no photo or video recording policy. And anyone who tries to violate that, move on. Move on from them. You want to find a better client who's going to follow the rules and is going to be honest with you. We all know how it feels to be brain drained. We'll say that. I think that's the polite way to say it. Where someone's coming in and they want you to tell them the steps and then they want to go do it themselves because they think they've got a handle on it. If they had a handle on it, they wouldn't be talking to you, right? So be very selective in your recording policy in your office. Of course, we want to vet information. Again, we talked on that a little bit. You want to make sure that the information your client's giving you makes sense, that it's believable, that it's credible, that it lines up, that it's consistent. If your client's bringing in their driver's license and their spouse, the address on it doesn't match, you got to know why. You have to document, you should document what was the reason they gave you that we've got two different addresses here. And that may actually be a strategic question now, especially, always has been, right? For us, we would say, hey, well, I know you just got married and you just moved in. So right now your driver's licenses are different. Go change it. Then bring us the new one that's the one we're going to submit because we don't want to get an RFE on it. Right? It makes sense. And they'll appreciate that as well, that you're looking out for them. And here's a really important one. Here's a very important part. Just the fact that we know that USCIS, FDNS, ICE, the greater immigration universe is tightening up enforcement along all fronts, right? Looking for fraud. They're going to be making false accusations of fraud as well. They will make unfounded claims. That's just in the numbers. That's how it works out. If they're going to make more, there's going to be some people who get caught in it when it's like, no, look, I just didn't have enough documentation to prove my legitimate marriage, but we're still married together. We got a kid now, and all this other stuff is happening. And if they're going to rope the attorneys into that, you need to take care of yourself, right? That's why you're documenting everything. But don't forget about your malpractice policy, right? In some states, it's required. In some states, it's not required. Even if it's not required, it's not that expensive to get a malpractice policy that's going to protect you in situations where you find you need to defend yourself either in court or with your state bar or with a government agency, right? You might need to get your own attorney, and a malpractice policy is going to help with that. So make sure that that's up to date and that you have the coverages that you want or need for that as well. All right. So we've talked a lot about fraud. We've talked about how this really is not just letting immigrants know that the government's going to be looking at this stuff, but this is a shot across the bow of a lot of immigration attorneys as well. We know that there are immigration attorneys out there who are high volume practitioners where they specialize maybe just in VAWAs, and they're filing thousands of VAWAs per year, or thousands of U visas, or thousands of T visas. In fact, I looked at the numbers, and let's pull up some numbers right now. Okay, because when we're looking at these things, we know there's some practitioners, they're filing a lot of these applications. We can see just judging by the first 2 quarters in 2025, right? So by the first half of this year, there was something like 11 million immigration applications pending with USCIS. And if we look at the breakdown of those, we can see here there's approximately 900,000, so almost a million, immediate relative family petitions, 1.5 million other family petitions pending. And if we look at some of the more common ones where fraud is alleged, the I-751, right, the petition to remove conditions on residency, there's 236,000 of those pending as of the middle of this year. Some of the bigger numbers under the employment-based ones, I would say, I-140, there's 150,000 of those pending. I-765s, just employment-based ones, just work permits, something like 400,000. No, not 400,000. Well, there's different categories for those. Asylum ones, 444,000 pending ones. Adjustment of status ones, 190,000 pending. All other categories, 1.3 million. Okay. Those aren't the biggest ones, I guess, for fraud, except maybe if they're asking about the asylum ones. But if we look at DACA is mostly under control. Here we go. The application for T visas. Okay. I gave some numbers earlier in the show that was wrong because there are 40,000 petitions for a T visa pending. Okay, they can give out 5,000 a year. 8 times 5 is 40. So you're about 8-year waiting list. That's phenomenally long compared to a few years ago when it was like the same year you would get it. Okay, 8 years. So that's why people are they'll still file them because they want that work permit quickly. But there's 40,000 of those, and those are going to be scrutinized. 412,000 pending U visa petitions. 412,000. Okay, so when I meet with clients, we say, well, it could be like you might be waiting 20 years, 10 years. Now it's like 40 years because they can only give out 10,000 of those per year, right? Some of those will drop off because they'll go back, get removed, or pass away, or find another visa, things like that. But it's enormous to have 400,000 of those visas pending at this time. Other popular ones to be scanned for fraud, I think those are probably the biggest ones. And then, because we talked about the family petitions Yeah, and U visa, T visa. Let's see if we've got. I see some numbers on the I-360, but I wanted to see it broken down by case type. So I don't know exactly how many VAWA petitions are being filed, but under the I-360, which has multiple, under the I-360, there's about 200,000 based on that. And that's not just VAWA cases. That would include others like special immigrant juvenile status, Amerasians, and other types of cases, religious visas, things like that are on the I-360 as well. But again, a significant number. So expect to see that tighten up. But this is not the end, right? So this isn't the end for immigration law. This isn't the end for immigration attorneys. It's not even that bad if you think about it, right? Let's find the silver lining now. What's the silver lining behind all of this? The silver lining is your client, if they decide not to hire you, their chances of getting their case approved just dropped significantly because they don't have the experience. They don't know, how much weight this type of evidence is given. This is their first time probably doing it. Whereas you as an attorney or immigration professional, this is your job, right? You do this every day. You have a lot of experience over the last decade to more doing these types of cases. So this is going to be second nature to you. Whereas for them, they're going to be found floundering. And so maybe what you'll see, and this would be a good idea just to come up with a policy in your firm for this as well. Maybe you'll see somebody come in for a consultation, try and do the brain drain thing on you, right? Well, what can I do? Oh, what kind of case is that called? Oh, what kind of forms do I need? Oh, do I get a work permit with that? Oh, and sort of go down that line of questioning. And then you sort of know what they're really after. Some people are just interested in details because that's their personality, but when they're starting to think about doing it on their own. They may disappear, right? They never hired you. They come back a year later, say, hey, I got this RFE or this denial. What happened here? And can you help me? Have a policy in place, right? Because there's two sides to it. I do want to be the person they come back to if they try it on their own. I do want them to come back and say, hey, we had a good experience with you last time. Sounded like you knew what you were talking about. Can you help us now? Well, I'm not going to be giving out any discounts on a case like that. Now there's stuff I got to go proactively fix. Things they may have submitted that have bad information in it or inaccurate information, right? So just have an idea right away. So when a client like that comes in and now there's something you got to fix because they tried it first, you know what your price is in that situation. And it's not out of vengeance or to teach them a lesson because it won't teach them a lesson. They've already gone through it. They've already learned the lesson, especially if they're coming back to ask for help. But it just needs to be part of your policy because it means there's more work and the attorney's going to have to personally deal with a lot of that on their own. Okay, so it's actually an opportunity. The silver lining here is this is actually an opportunity for immigration attorneys to distinguish themselves from someone who's not a licensed attorney or from someone who is just a notary public out there unlawfully practicing law or someone's cousin's cousin or friend of a cousin's cousin who doesn't know anything but are happy to take money. It's a way to distinguish themselves and to build their reputation, right? Be the expert in these situations. So I want to thank you today for joining us. That's going to conclude our show for today. I hope you found it interesting and enlightening. These tips that we've given out, review your retainer agreement, review your malpractice policy, review your policies on when clients are allowed to take photos or videos, when they're allowed to call someone on the phone in your office to participate in the conversation. Just make sure you know everyone who's participating, right? Use good judgment. And as always, we're brought to you by our sponsor, Prima.Law. Now, Prima.Law is immigration case management. It is not just filling out forms. It's not just checklists and tasks. This is the full immigration case management system. It is a case management system. It's not just forms. We have an amazing smart table for case management. We have a case management board so you can tag your cases. You can easily filter through them and say, show me all the I-130s. Boom. Show me all the U visas. Boom. Show me all the U visas where we're waiting on the client. Boom. And you get a list and a report. It's very nice. Same thing for managing tasks, phone calls, all things like that we have built into the system. So you don't need to try and wire or, use other third-party tools to connect these different services together. It's all built in. Great system for task management, phone call management. Text messaging is integrated, fully integrated. So You don't need to give out your cell phone number, but you can have a complete record of all the text messages between you and your client. And the greatest thing now is because we took the time to build a nice, solid infrastructure, right? We have been able to add some AI features, right? So you can do things like when your package is fully put together. I didn't even mention that. We have a great package assembly tool. So you can add your exhibit sheets. You can create a table of contents automatically with page numbers, with the footer, the page, in the packet, everything's got page numbers on it if you want. You can use exhibit sheets to divide things. You can now use letters or numbers. So that's helpful for the court practitioners as well. But you can tell the AI, you say, hey, is this a complete package? What could I add to make it stronger? Is the data internally consistent? Is the petitioner's name spelled correctly? Does it match their birth certificate? Does it match their other government documents? It'll look for anything that could be a deficiency in your case, and it'll warn you about it before it gets sent out, because we know the government's going to have a lot less mercy, and they're not going to be issuing RFEs nearly as often. They have, look, we read off the numbers. 11 million cases pending. For crying out loud, they're not going to issue RFEs. They're going to issue a denial and say, start over if you really want it. That's going to be their attitude from now on, even though it's not supposed to be. We know that's what's going to happen. There's a lot of stuff that's happening now in government that's not supposed to be that way, but sure enough, they're getting away with it for now. So the AI case review tool by Prima is, it's trained to know what your cases need. It's trained to find the holes in your case. It's trained to tell you, it can tell you how you can strengthen that case so you can avoid that situation. And especially when we're looking at processing times like 3 years for a 601 waiver, over a year for an I-130, things are not going very fast, and they're probably going to slow down a little more before they get faster. You don't want to give the government any reason to return your case. So find a free 15-day trial at www.Prima.Law. And, I didn't even mention that we have the email features on, right? We got a great email integration with Outlook or Google. So it's going to filter those emails. It's going to file them away automatically for you. It's fantastic. So you find a free 15-day trial at www.Prima.Law. And that's going to end it for us today. Thank you so much for joining us. Remember to like and subscribe wherever you're listening.